let's have it in order that we have the DCI, right? The person I wanted.
Yeah.
We're not. I wanted to agree how we proceed. That's
I'm actually drawing from your wisdom, my lord, that in this particular instance, as we left last time, was the life liberty of the petitioner, second petition. And we are glad that he's here. He's alive, he's breathing. We were ready to cross-examine him. But the family has made a we are saying we're going to the request to debrief under which he could be traced. Then we reconvene. In the petition, all parties come back here. And my lord, the only point you were stressing, which now so having blocked his diary for today, no prejudice will be suffered if we proceed with him today. But if the court is minded to consider the family request, we'll equal together. And also, my lord, of import in this particular instance that we don't lose focus on. Yes. In the replying affidavit signed by the respondents in paragraph 20, the question
I have which
the affidavit sworn on 30th of June 2025 by Samuel Iteg.
paragraph 20.
Paragraph 20. There's a live issue which I will not wish that will be lost over. If the second petitioner were to leave court today, there is a real danger that he may be arrested or detained by the respondents. On his behalf and in the interest of justice, I pray that when the court is making directions as regards to the second petitioner, the court consider issuing an order restraining his arrest. If any arrest ends up in court, and he can be bonded to attend to this court when required, so that the question that should be of our primary concern at this point is him getting medical attention and social support.
In fact, my lord, will be happy if the director will just tell us that we will not arrest. For free. That we go just probably just also for the court to feel the presence.
I confirm the application for protection of the second petitioner this time. This is also one you are going to make, so I had to participate in giving its directions.
Yes, Mr. Victor.
Yes, my lord, thank you. My lord, I have an application to make. First application I wish to make, my lord, is that the court will be gracious to summon the diplomat who swore an affidavit in support of the petition, one Florence Muturi, to attend court during the next hearing for us to cross-examine. Because, my lord, there are certain facts that should be want to that have led us to this. There are two affidavits. The first one was sworn on the 1st day of July 2025. 2025.
Which date?
1st July 2025. And there is another one sworn on the 24th day of June this year.
So, Mr. Victor, you should begin sequentially. Hurry up to the latest.
The first one is on
24th.
24th day of June 2025.
First.
Yes, that is the first affidavit. The second one, my lord, was performed on the 1st day of July 2025. Both in support of the petition and the motion.
Yes.
Secondly, my lord, in terms of the directions of the court, my lord, now that the DCI has come, once it was summoned, pray that those directions be discharged as regards the hearings of the DCI. And thirdly, my lord, the DCI, in light of what has been stated, wish to be given an opportunity to speak on behalf of the directorate. Was
Have an opportunity.
to address my lord on behalf of the directorate, because they feel that they have not been treated fairly as regards this case, and they need to be heard. An opportunity to be heard as regards all the issues raised. Fourthly,
So, I didn't get you.
yes, he wishes to be heard. Wants to be heard.
Today.
Today, my lord, before you, now that you've summoned him, wants to be heard because they have not been treated fair.
They say so.
Yes, they need an opportunity to state the facts. Hello? An application has been made orally. I am not privy to the basis of our application.
Which one?
The one for, there were several applications made by Mr. Kibe and Mr. Okabata.
Yes.
Yes, and Mr. Willis Otieno. I pray that we make a formal application so that we have an opportunity to respond.
You are mixing up.
My lord, I've addressed you
Let me
first.
see whether we are speaking.
Correct.
Mr. Kibe made a specific request on behalf of the family and there will be one time with the special petition. That's number one, and that's the primary application I have for Mr. Kidd. So what do you say to that?
My answer
Don't
is
mix his
yes.
and the other people.
My answer is simple. Mr. Kidd is not a party in this proceedings. He is not a party in this proceedings. I have no problem with him meeting the second petitioner in whatever capacity of the. But he is not representing any party in this proceedings. If he was, I would be in a position to respond to an application made by a party.
So you're not able to respond.
My response is Mr. Kidd is not a party in this proceedings. He cannot make an application in proceedings that he is not part. There is the application made by Mr. Willis Uzalendo. And I believe, Lord, if you look at the notice of motion, filed by the petitioner.
Yes.
There is a prayer that was sought for the unconditional release. And prayers of habeas corpus, Lord. Look at prayer 8, Lord.
That's in the original motion.
It is in the notice of motion, Lord, the one that gives direction.
Yes.
Dated 24th of June. You've seen it, Lord.
Yes.
Yes.
Which one are you referring to?
I'm referring to prayer number 8, Lord.
Yes.
Prayer number 8. So that, my Lord, this is the prayer that has been sought. We have responded to this motion, Lord. And we are ready for it to be urged, Lord, inter partes. And I believe it is only fair that we deal with this motion, Lord, before we consider any other oral application. I believe that you're coming for directions, Lord, so you can give directions over here so that we conclude with this interrupted application. And that is my brief response. My Lord, in response.
Before you respond,
Yes, my Lord.
I want to find out whether I got Mr. Peter. What you say, Mr. Peter, is
Yes.
that you want the DCI to be allowed to speak.
Because we called it.
Because-
Come on,
Yes, yes. I'm not saying I just call him. Why are you here?
Yes.
That's all I want to hear.
Yes.
Because the petitioner, the family has a specific request. The petitioners, counsel for the petitioners have their way of looking at things. So I want to know whether you agree with that you hear him today, despite the request from the petitioner's family.
Despite the request, my lord, because of the schedule.
So I have no problem. I just wanted to know whether that's the way you want us to proceed, so that I give directions.
Yes, please.
Mr. Mugabe?
Yes. My lord, first of all, it is very strange for the Honorable Attorney General to present to the Attorney General the Constitution in Article 156 of the Constitution, I believe sub-article 6, talks about the Attorney General shall promote, protect, and uphold the rule of law and defend the public interest. This is a habeas corpus application, the subject matter of the petition.
Yes.
In a habeas corpus application, and by the nature of habeas corpus, the family is a necessary party, and invariably habeas corpus application are instigated or instituted at the behest of the family. And therefore, for purposes of these proceedings, where the second petitioner is indicated as Ndiang'ui Kinyagia was not there to give the instructions, that should be construed as the family of Ndiang'ui Kinyagia. So the family of Ndiang'ui Kinyagia is already a party. And if it was not expressly, it is a necessary party whose right to participate is inherent in the nature of habeas corpus. But if, for whatever reason, it is necessary to comply with technicalities, notwithstanding Article 159 of the Constitution, that litigation, particularly under this jurisdiction, shall not bear regard to undue technicalities. I wish, pursuant to Rule 10, Sub-Rule 4 of the Mutunga Rules, to make an oral application for the family of the second petitioner to be added to the proceedings as a third petitioner. But the primary position is that they are already parties if the second petitioner is a party. And that is pursuant to Rule 5. Is it Rule 5? Rule 5 of the Mutunga Rules. That this court has jurisdiction under those two rules, 5 and 10, to make such an order. And my lord, the last one is a question of common sense and propriety of proceedings. the notion as urged by the Attorney General that you can have proper habeas corpus proceedings in which your lordships can lock out the families and their representatives from speaking would be completely unusual. The only issue that we need to clarify is that when I advise that Lilian Wanjiku Gitonga to file an affidavit, I advise that you come as an interested party. So for purposes of Lilian Wanjiku Gitonga, who gave us the information, will appear as an interested party. But now that he is there, and when we speak to Ndiang'ui, the second petitioner, then we would be able, for purposes of completion of the habeas corpus proceedings, to be of further use as are dedicated to the court. Because all of us, even out of curiosity, want to know where was he? And why has he also just appeared a day before? We want to know that also, if nothing else for purposes of curiosity. Therefore, we need to talk to him, as we had requested, but we can formalize the proceedings because we need to apply for his protection. We must oblige for that.
Madam, we have a right to reply on my application.
Which one?
The question of the liberty of the individual and the need for him to be given an opportunity to get medical attention. He looks physically traumatized. I'm not an expert, but applying my elementary knowledge of
So
myself.
if you continue talking, he wants medical attention, what are we going to do?
That's exactly what I was going to say, that we should not talk too much, but we should by issuing the order that allows his liberty and an opportunity to access medical help.
Where I am, I think we are losing the point. I have the DCI report. I have the petitioner report. The family has requested to have a conversation with the petitioner, second petitioner. I have parties who want to keep us here. We want to hear the DCI, Mr. Peter says they were not treated well, he will tell us. The other side wants to examine the DCI. So how do we proceed? Which one should we give preference to? It is something, a decision we have to make conscientiously. If the health of the second petitioner is primary, or do we keep the DCI here?
My Lord, I think we should give way to the family and parties. Those who are needed by the court can come on the next date. The application was about the well-being of the second petitioner. And I think in all fairness, we ought to give way, even though we were rallying to go, we should hold our breaths.
Mr. Vista,
Yes, my lord.
how many documents do I have? I have 3 affidavits from William. Is that Mr. This one, third, second, the seventh, first one, and I believe that's good. It seems to be the same.
No, my lord, the first affidavit is by Samuel K.
That I have.
Yes.
That's the original.
Yes, that's the original.
That one you have.
Then we have a second, a further replying affidavit by Leonard Seattle. That one is sworn on the 2nd day of July.
So is that one of William?
Yes. So there's Leonard Seattle, and then there's Patrick Will.
The first one is?
The first one is by Samuel Kuti.
Yes.
That is the first one.
Yes. Yes.
The second affidavit is by Leonard Seattle.
Not have that one.
We don't have it.
The third,
The third one is by Patrick Will.
I have 3 copies by Patrick Will.
Maybe they printed the same thing. But we supply, we have copies of it.
Let's check. Did you upload the one on Sierra?
Mr. Marwan actually uploaded it. He's here, I can speak for himself. He personally uploaded
No, you are now the lead.
it. Yes, ma'am.
I told you are his senior.
Yes, and I trust him.
So how do you throw it back to him? Because you are the one, I'm looking at the system.
Yes.
It is the same affidavit by Sweden that was uploaded. It was uploaded twice. Someone else who can assist me, maybe we are wrong in this time.
There is I've given a physical copy right now.
No, it has to be here. So this is the file. Your people can upload it now. Let's see the have you seen the one by 7?
Yes, ma'am.
One by 7. We don't have it.
Well, he can re-upload it. So
Yeah. We are still trying to confirm what the systems are. Yeah, it's here that you uploaded with it twice. I'm sure it is because of the address. Anything else?
I wanted to address your question on an issue that Mr. Peter has raised that my senior Mr. Superior sees important as better. He's 38 years in the profession alone, and to me that counts for something.
Please, my lord, leaving what my vice president has said, I am the second senior most after senior counsel Karoa. I just wanted to bring the context on the 4 applications made by Mr. Vita. The first one was on the summary of the CEO of the Law Society. I appeared for, together with the rest, for the Law Society and the second petition. As to that application, the Law Society has no objection. In respect of the first application by Mr. Vita on the question of cross-examination, which can be dealt with at the appropriate time. What I am worried about are the second and third applications by Mr. Vita because they go against each other. The second application was to discharge the personal appearance of the DCI. But the third one is to give him an opportunity to address court, which is sort of supporting what my other learned colleagues had said about having a bite at the cherry today. So that third application also supports what the other parties were saying, that he can be able to say something. He cannot just say it and go. He may have to be asked some questions in relation to that before his discharge. So while dealing with those 2 applications, you may have to consider how to balance the 2 of them in relation to having given him the opportunity and then thereafter discharging him and whether he is cross-examined. Then as to the question of a formal application being filed by Mr. Kibi, I think that has been addressed, and that was the 4th link of Mr. Vita's application. So those are the 4 issues I wanted to bring to context for purposes of then when your lordship is giving directions, then you can be able now to balance what Mr. Vita requires, what we also require, and the fact that at a later stage, since the other affidavits are supporting the petition, they can be dealt with in the main petition, and the deponents, including whoever may be required, a notice can be given as is required by law that we will want to cross-examine you on these allegations or these depositions in your affidavit dated this particular day. That will be all.
Let me make it clear that the court is never addressed. It's the lawyers who address the court on specific items. So if the DCI wants to speak, we will take to the witness box. He's here as a witness of the court. He's led what he wants to say, and then he will be subject to cross-examination.
Thank you.
Those are the directions. If we are going that way, we clear the way for that. Bearing in mind, I have a specific request from the family.
Yes.
So if you want us to go that way, we take the stand, be led for the reasons that the court directed you to hear, nothing more.
I think my learned senior, my learned can be able to now.
So you look at the directions at issue, you will be here for specific conditions, you are not addressing any other issue. If we are sticking to that, that's what we are doing.
Yes, Lord, let me address you on that because I received some instructions. He says he wants to respect the issues of the family. Now that he has answered from the summons of the court to appear, and the second petition is present, that you're discharging, because that was summons have been paid.
What is he telling you?
No, he's telling me to abandon the other applications.
It's already on record. And all applications is already on record.
So as regards to this time, my lord is that in discharging, doesn't wish to pose the wish of the family. Those summons are actually expired.
Lord, on that application, Mr. Bita, I hope will be given an opportunity to reply.
Mr. Bita, you have filed all you have filed in response to the petition.
To the petition, no. I was just dealing with this aspect. Because you know there are other parties. The accusation against other parties.
So you have not filed responses to the petition.
As regards the other parties, but as regards the IG, the DCI, both in their public and private capacities,
You have filed.
Yes.
And those are the primary parties.
Those are the primary parties.
So my concern is there any other thing you want to file in form of a response?
Our file grounds of opposition on behalf of the other parties that are not primary. That is the Attorney General and the Cabinet Secretary of Nigeria. But today is Thursday. By Monday, we'll file it.
You know, file. I'm suggesting that we go directly to the petition.
That is okay.
You agree? Petitioners?
We're fine with that.
No, I can also file an appeal.
That's a response, Mr. Speaker.
Yes.
Ask Mr. Brown, I think he comes to my case so often. He knows our responses to the petition.
I'm not a bit, your court no other than Mr. Maro.
I don't know when last year. But I'm sure you know.
Yes, my lord.
So next week, so I can give you 7 days.
Yes, my lord. That will be okay.
Senior counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think then
10 will do.
what do yes?
We are
What
dealing with
one?
the petition because there are specific issues.
Then make it maybe 15, 15, yeah.
Mr. Peter, would 15 be out?
More than that.
My lord, before you give your directions, perhaps you consider that the case be disposed by by both submissions and viva voce evidence, because we still have that for the examination. I think,
We already have the affidavits. We will have the affidavits.
yeah, but we are not even talking of our witness. We are talking of cross-examining DCI and the deponent.
I'm talking of your case. How will you take to present your case?
I think our one day then.
One day.
Yeah, not more than 1 day. Yeah, it could even be less, but to be on the safe
You
side.
know, I have affidavits already.
Yeah.
Yeah, they will come here and adopt affidavit and be cross-examined.
Yeah.
And the way
Although
we
we have
proceed.
requested for somebody without any affidavit, the DCI, because it is his officers who swore, yet.
We will reach there.
Okay.
Let's deal with you.
Okay.
I'm looking for your side.
Yeah.
Don't worry, because they will come and they will cross-examine. Do you agree?
3 hours for highlights, but cross-examination would be a day plus. We had prepared already.
Are you suggesting there are days you come without preparing?
No, but because of the problem we are talking about, we had come loaded more than usual.
That you take so long.
Yeah.
I'm suggesting 17th and 18th of July for hearing.
May I request we push another 2 days? I have a personal problem. I'll be out I'll be returning on 16th and 17th. I'm in Kampala. So if I and Kampala, I'm lead counsel.
No, you said you are not available, so we...
Just by 1 day.
Okay. No problem. When are you in Kampala?
On the 17th.
17th.
Yeah.
Will you fly back? You don't
It's
know.
a day trip.
No, will you fly back the same day?
Yeah, it's a day trip. That's what I'm saying. Going in the morning, back in the evening.
So we can take 18.
Yeah.
Can take 18.
No, they welcome me. No, I'm supposed to be in there.
So we'll have to stagger it. We take 18th, and then we'll proceed on 24th. How is that?
That's okay.
Mr. Bito?
18th, that's okay.
24th.
18th.
That's okay.
Some time allocation or
I will come to that. Let's just agree.
The mother is not here, so wow, congratulations. Wow, yeah, yes. Wow, congrats. It's going to year 3. Call myself Granny Mommy. It's my daughter.
A doctor from China showed the world how to slow down aging.
No, I apologize.
So I suggest we start 10:30 each day.
9:30. 10:30, it's okay.
That's okay?
that's okay.
The petitioners will have 7 days to file a supplementary affidavit if need be. Have the petitioner with them and take him to hospital for medical attention. This matter will be heard on 17th and 24th of July.
18th, my lord.
18th of July. Inclusive. In the meantime, shall not arrest the second petitioner, Ndiang'ui Kinyagia, a petitioner in this matter, and may be required to testify. Advocates, but he should not be arrested or detained